the entirety of the emails that.
Then the court has a question regarding, and I don't want you to argue and state the content of the email, since the court hasn't ruled on this portion yet. Tab 5. Starting with the third paragraph from the bottom. All the way to the end. Can you tell the court the relevance? And that's a portion that wasn't contained in your proffer.
And right now we're just doing some preliminary issues before we get back into starting the actual witnesses testifying. As you know, if you came back in or if you haven't heard, the judge is allowing in the emails. Those are the emails that we talked about a little bit that were not from the actual defendants in this case, but from other law enforcement investigators and higher-ups in regards to this investigation. So I'm not, to be honest, I'm not clear as to what the judge's reasoning was in regards to why they were letting it in. You know, maybe there'll be some further explanation of that, but as you note, all the defense attorneys objected, and so I assume we'll be hearing some of those emails, as I believe that's the last witness that will be testifying. Let's go back into the courtroom.
Provides context for what is very relevant at the end of the next case. But those, I think, those two paragraphs that you, those first two paragraphs that you said, we could take out, and it would not affect the relevance of the exhibits.
Any further argument on that, Mr. McKay?
Huh?
Do you have any other argument?
Yes, Your Honor. Regarding those two paragraphs?
Or the remaining paragraphs?
I want to
They're agreeing that those two paragraphs should be redacted.
I don't agree. I don't agree.
Oh, you want them in?
Over my objection that any of these go in. If they are going in, I want them all in that.
Okay.
I want in their entirety.
Okay. Mr. Pugh?
Your Honor,
Mr. Breen?
Your Honor, I think that I'll just restate our position. I don't believe that any of this has any relevance to Joe Walsh whatsoever. That would be our objection, is that the other emails have no relevance to the case against Joseph Walsh.
Mr. Fahey?
Judge, we would join in that objection. The author of the email, my client, doesn't know. He wasn't a part of the email chain. He doesn't know any of the person who authored this email, and he doesn't know the person that it was sent to.
And I believe those objections were made when there was argument on the co-conspirator statement. My ruling stands. It will be admitted. Then, since there's no, other than the objections you previously stated, Mr. McKay, you're saying you want the entirety of it in?
Yes, Judge. Regarding this exhibit, the state wants to redact these two paragraphs. I would submit.
No, I asked.
I'm saying I don't agree that those paragraphs should be redacted.
Then they'll go in.
Thank you.
Okay. Same for you, Mr. Pugh.
Yes.
Same for you, Mr. Fahey.
Yes, sure.
Okay. Tab 9. Mr. Saper, can you argue the relevance of that?
That would be our objection is that the emails have no relevance to the case against Joseph Walsh.
Mr. Fahey,
Judge, we would join in that objection. The author of the email, my client doesn't know. He wasn't a part of the email chain. He doesn't know any of the person who authored this email, and he doesn't know the person that it was sent to.
and I believe those objections were made when there was argument on the co-conspirator statement. My ruling stands. It will be admitted. Then, since there's no, other than the objections you previously stated, Mr. McKay, you're saying you want the entirety of it in?
Yes, Judge, regarding this exhibit, the state wants to redact these two paragraphs. I would submit.
No, I asked.
I'm saying I don't agree that those paragraphs should be redacted.
Then they'll go in.
Thank you.
Okay. Same for you, Mr. Pugh.
Yes, Judge.
Same for you, Mr. Fahey.
Yes, sure.
Okay. Tab 9. Mr. Saper, can you argue the relevance of that?
So Your Honor, first of all, it is clear that what is happening is these officers, and would you, so I'm going to speak cryptically.
Sure.
Until they are, because they're not in evidence.
Correct.
So these officers are at the very top of the email, and I'll go to the bottom in a minute, but are working to assist their fellow officer in a defense during an open investigation. And that's not, that's just not police work. That's not proper. That is that's part of a conspiracy to conceal what has happened, to avoid prosecution. Now, if you go down, they are asking for permission to produce, I would say generally, police information to a non-police person, which is, of course, totally improper, for the benefit of disseminating that so it could help an officer who is under active investigation. Finally, at the very bottom of the second page, it identifies who that person is who is outside of the Chicago Police Department, to whom they are seeking to release this information, and from whom they are seeking to get assistance, again, in the case to help this officer, all of which is improper.
Any further argument, Mr. McKay, other than what you've already stated? I know you object to it, well, any of the emails going in, but is there anything other than that?
No, Your Honor.
Okay. Mr. Pugh or Mr. Green or Mr. Stanley?
No, Your Honor.
Okay, Mr. Fahey?
No, Judge.
Okay, based upon that, the court's going to allow that one as well. I think that addresses the issues that the court had. So, as I said, the defense objection is respectfully overruled. So, Are the parties ready then to proceed?
We are here.
Okay. Then state, call your next witness. Before the witness comes out, I just want to address something that was brought to the court's attention or file stamped. It was a letter from Natalie J. Spears, SPEARS, from Denton's US LLP, asking that the court reconsider allowing the monitor for the media to display any exhibits, or that they have a copy of the exhibits. The court has reconsidered, and the court's ruling stands that there will not be a monitor and the exhibits will not be tendered for the reasons that the court stated in an in-camera hearing with Ms. Fusco. All right, you may proceed.
Your Honor, before the state calls its next witness, the state intends to use the same exhibit, books, and examination that the state used previously.
Okay.
The state also, with Mr. Maris, who will be the next witness, intends to offer additional emails as public and business records, not as statements in further of a conspiracy.
Is there a stipulation regarding that?
The witness will testify to it. I wanted to hand out copies of these exhibits before providing the exhibits to the witness.
Any objections, Mr. McKay?
I need to see the,
Not to the exhibits.
I need to
Just,
see the exhibit.
okay, then show them to the defense, please. The defense had an opportunity to look at the, did you say the stipulation?
We intend to offer it as a
Exhibit?
as a business and public record with the witness.
Okay.
That it will be identified as CPD email 13, CPD email 14, and CPD email 15. Your Honor, I have additional copies for the court to insert and review.
All right. Have you had an opportunity to review it, Mr. McKay?
Yes, Judge.
Any objection if the court receives a copy of it now prior to the witness testifying?
I have no objection to you looking at it. I have objection to the admissibility of them.
Okay. We'll take that up at the, do you want to discuss it now?
We can discuss it now.
Okay. What's your objection?
Your Honor, these emails that have just been tendered to us are not relevant to the charges before this court. Exhibit number, well, tab number 15, which is CPD email 13, includes links and communication from the media in this case. That is far more prejudicial than probative, among other things. If we are convicted, if we're trying to suggest media accounts are evidence, we are in a very, very sad state of affairs when it comes to due process. So that's for tab number 15. Tab number 16, Your Honor, purports to be CPD email number 14. This, again, is an email that lists several links and information, again, from media outlets suggesting various things per somebody from the media. That's not evident. That's more prejudicial than probative. That's not relevant and material for the charges pending before these three innocent men. And regarding tab number 17, which is email CPD 15, this is dated December the 5th, 2015. Nowhere are these three defendants listed in this particular email, and it is so far removed from the police reports submitted in this case. This is months, several months later, that it is not relevant to the charge before this court, and is prejudicial far more than probative regarding the charge before the court against these three men. So for those reasons, Judge, I have to object to these three exhibits being admitted.
Thank you. Mr. Pugh or Mr. Breen, Mr. Stanley?
Your Honor, I don't know. A relevancy objection, and as been legal play hearsay objection as well. So based upon that, I don't see any relevance to this, particularly the media stuff, but maybe the state can tell us what the relevancy is.
Thank you. Mr. Fahey?
Judge, we would also be joining in the objection on the basis of relevance and also on the basis of hearsay.
Thank you.
I join in the hearsay objection because I failed to make that. I
That's
want to state that for the record.
All right. Thank you. Mr. Watson?
To the hearsay objection, it will be offered as a business and public record pursuant to Mr. Maris's testimony. That was all hearsay objection. As to email 13, the state is offering it for the purpose of showing when the dash cam video of the fatal shooting was released. That is identified in paragraph 2 of the indictment, that the co-conspirators lied about what occurred and mischaracterized the video recording so that independent criminal investigators would not know the truth of the Laquan McDonald killing, and the public would not see the video recordings of the events. The co-conspirators understood that public airing of the events surrounding.
I'm going to ask you to slow down.
I'm sorry.
That's okay, so the court reporter can take it down. You may continue.
The co-conspirators understood the public airing of the events surrounding Laquan McDonald's killing, including the video recordings, would inexorably lead to a thorough criminal investigation by an independent body and likely criminal charges. So the state is offering CPD email 13 in order to establish that the dash cam video was released on or about November 25th of 2015. state is offering CPD email 14 for the purpose of showing when the city released the police reports on or about December 7th, 2015. We've heard testimony about when the police reports were released, when an officer had an opportunity to review the police reports that were in the media, because the officer testified, or Fontaine testified, that she followed the link. That information is relevant. It also is relevant as to paragraph 2 of the indictment, which I identified for the court, that the co-conspirators understood that the public airing of the events surrounding Laquan and Gallo's killing would inexorably lead to a thorough criminal investigation by an independent body and likely criminal charges. That's the purpose and the relevance of CPD email 14. The state offers CPD email 15 for that same purpose. CPD email 15 states that it would be wise to alert all officers that the city and the department has released the investigative file. Check Tribune site for article/file. That email is sent to the FOP. Then that email is forwarded from Wojciech to Gallagher. Dan, FYI, see below, so FOP could let officers know. Where it is heard testimony about when police had the ability to see the reports, that goes to prove that fact. That's why it's relevant.
I need to see the emails to read them, to see if they're relevant or not. Any further argument, Mr. McKay?
No, Your Honor.
Mr. Green or Mr. Pugh?
Judge, only that based upon the proffer the state has made, they're attempting to put in, you'll see when you read it, what appear to be capsule summaries of, for instance, CBS News, concluding that a video was not consistent with earlier reports by police officers, and they seem to be offering that as evidence, according to what I just heard, that the co-conspirators that are charged here were aware that their actions would lead to an independent criminal investigation. I do not see any nexus between these emails and that statement, which was contained in the special prosecutor's pretrial submission. There's no nexus at all between, for instance, our client. I think I can speak for everybody, but there is no nexus here to show that. So what they're doing here is just basically handing you a capsule summary of a news article and said, see, we've now proven that there would have been an independent review of the facts and circumstances of October 20th, 2014. So without that nexus, I don't believe there's any relevance whatsoever. And to kind of try to slip this in for some kind of business record exception doesn't strike me as a jury issue for business. Thank you.
Judge, I would join in that objection. It's also important for the court to know that first email is from November 25th of 2015. At that point, the criminal investigation was just about concluded. I do not know the exact date, but I believe that's the same one that Jason Van Dyke was indicted after the independent criminal investigation. So it certainly has no relevance to the proceedings here. It's hearsay. Yeah, there's nothing that is relevant with regards to Thomas Gaffney or any of these other two men on our trial. They had no control over when the video was released. The evidence is shown and suggested is Dave Marsh was the one who preserved the video for the independent criminal investigation. You also have the transcript of Thomas Gaffney, who testified in the independent criminal investigation back in July of 2015. So I don't know the date of the indictment of Jason Van Dyke, but I want to say it was right around the same time period. So it's not relevant at all.
I join those objections.
Okay. Thank you. Mr. Watson, anything further?
The state is offering it for the purpose of showing the date, showing that Chicago releases dash cam video after cop charged with murder. That is in the CPEC email. That email is forwarded throughout the Chicago Police Department as of its business practice. The CPEC is this would be the subject of Mr. Maris's testimony. The Crime Prevention and Information Center that Chicago Police uses to disseminate information in the department.
I believe you'll be able to lay a foundation.
Yes, Your Honor. Court can reserve
I'm going to.
as to
I'm going to reserve ruling until I hear the testimony and see if it's relevant or not, and if you can lay a foundation.
very well.
All right, so call your next witness.
Court calls Steve Maris, Your Honor.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Good morning.
Good morning.
Could you please introduce yourself and spell your name for the court reporters?
My name is Steve Maris, Steveemaris.
Mr. Maris, where do you work?
I work for the Chicago Police Department.
What is your job at the Chicago Police Department?
I'm Director of Information Services Division.
How long have you been the director?
About 2 years.
When did you first start with the Chicago Police Department?
Initially, I started in October of 1994. I was there for approximately 13 plus years. Left for 8.5 years to work in the Chicago Park District, and I've been back at the Chicago Police Department for the past 2 years.
Briefly, could you tell the court what the Information Services Division is?
That's a division in the Chicago Police Department that's responsible for all technology, computer-related, information-related services related to police business.
Does that include email?
It does.
Are you a civilian member of the Chicago Police Department?
Yes.
As a civilian member, are you required to obey all laws and execute all lawful orders of the department?
Yes.
Are you also bound by the policy, rules, regulations, and orders of the department?
Yes.
Why is the Information Services Division, or information services generally, important to what the Chicago Police Department does?
We're important because we're in charge of collection, security, and dissemination of information that we capture and record.
Does that include official police reports and records that are electronic?
Yes.
Does that include email?
Yes.
Mr. Maris, let's provide the court an overview of your testimony. First, are you able to testify about the systems for computer-generated reports at the Chicago Police Department?
Yes.
Are you able to testify about the rules and regulations that apply to email and information security at the Chicago Police Department?
Yes.
Third, are you able to identify for the court Chicago Police Department emails related to this incident?
Yes.
Let's start generally, Mr. Maris. The court has heard testimony and seen computer-generated reports from the department. Could you explain briefly how an officer logs into a computer at the department?
Every individual who works at the Chicago Police Department is assigned a user ID and a password, which allows them access to the computer.
Is that a PC number for an officer?
Yes,
Is a PC number unique to that officer?
yes.
And how do officers then use a PC number to log in?
They use the PC number. They're approached by a screen when they log in, so they enter their PC number and their unique password to log in.
And that access enables officers to send and receive email.
It does.
That access allows officers computer systems like Clear and Chris, if authorized.
Yes,
Does that access allow an officer to enter information on a police report, if authorized?
yes,
Does that access allow an officer to create a police report, if authorized?
yes,
Does that access allow an officer to print a police report, if authorized?
yes.
Could you explain what an electronic signature is?
An electronic signature is in lieu of someone signing their name on a piece of paper. They would use their log ID as password to attest or verify to a report or document.
Does the officer have a duty to retain control and maintain the secrecy of her or his password?
Yes.
Why is that?
Our general orders that are written about that specifically saying they used to keep your password unique to yourself. You can only use your unique log ID password combination for attestation and verification.
Let's talk about the rules and regulations of the department. First, are you familiar generally with the rules and regulations of the Chicago Police Department?
Yes,
Can we approach the witness?
Yes.
With the court's permission, may I show People's Exhibit CPD Rule 1, Tab 1, which is in evidence to the witness.
Other than objections previously stated, any objections to the case?
No additional objections.
Mr. Pugh?
There you are.
Mr. Fahey?
No, thank you, Judge.
Okay. You may proceed.
Mr. Maris, can you turn to tab 1 of the notebook or binder that's in front of you? And I'm showing you People's Exhibit CPD Rule 1. Could you tell us what that is?
rules and regulations of the Chicago Police Department.
Could you turn to page 10 and let me know when you're there? Let us know when you're there.
Yes. Thank you.
Mr. Maris, what does Rule 41 prohibit?
Disseminating, releasing, altering, defacing, or removing any department record information concerning police matters except as provided by department orders.
With the court's permission, may I show People's Exhibit CPD Rule 2, which is tab 2 of the binder, Your Honor. It's already in that.
Yes, you may.
Mr. Maris, could you turn to tab 2 and let us know what that is?
The rules and regulations of the Chicago Police Department.
What's the date or effective date of the rules and regulations?
Effective date is 16 April 2015.
Could you turn to page 10 of CPD Rule 2?
I'm here.
Does Rule 41 prohibit disseminating, releasing, altering, defacing, or removing any department record or information concerning police matters, except as provided by department orders in the same way that the previous exhibit, CPD Rule 1, did.
Yes.
With the court's permission, may I show People's Exhibit CPD Order 12, which is tab 3, and in evidence to the witness.
Yes.
Mr. Maris, can you turn to tab 3? I'm showing you People's Exhibit CPD Order 12. What is that?
Access to computerized data, dissemination and retention of computer data.
It's a Chicago Police Department General Order G090101.
Yes.
Does that order prohibit disseminating any department record or information concerning police matters?
Yes.
Could you turn to page 3 and let us know when you're there?
I'm here.
Mr. Maris, could you turn under paragraph 6A2 and let us know if this general order states access to information is restricted to official police business and access of information to personal or other reasons is strictly prohibited.
It does.
That includes Chicago Police Department email?
Yes.
Does that also include Chicago Police Department official reports and records?
Yes.
Let's talk next about specific emails. First, I want to ask you some general questions, Mr. Maris. Does the Chicago Police Department keep emails under the law, including the Illinois Local Records Act?
Yes.
Does the Chicago Police Department have a regular practice of storing email?
Yes.
Does the Chicago Police Department keep email in the course of its regularly conducted business activity?
Yes.
Does the Chicago Police Department keep email at or near the time the email is sent or received in the course of its regularly conducted business activity?
Yes.
With the court's permission, may I show People's Exhibit CPD Email 13, which is tab 15, to the witness?
You may show it to the witness. And I know that's only the defense objection.
Mr. Maris, I'm showing you CPD Email 13. What is that?
That is an email from the CPIC sent Wednesday, November 25th, 2015 at 10:30 a.m. to various individuals.
CPIC is the Crime Prevention and Information Center.
Yes.
Could you tell us generally what CPIC or the Crime Prevention and Information Center is?
They're responsible for tracking terrorist activity, suspicious activity, and disseminating notifications to the Chicago Police Department.
When was CPD Email 13 sent or received again?
Wednesday, November 25th, 2015, 10:30 a.m.
Did the Chicago Police Department keep CPD Email 13 in the course of its regularly conducted business activity?
Yes.
Did the Chicago Police Department keep CPD Email 13 at or near the time the email is sent or received in the course of its regularly conducted business activity?
Yes.
Did the Chicago Police Department keep Email 13 under the Illinois Local Records Act and the Illinois law?
Yes.
Could we turn together to page 2? Mr. Maris, what is the subject of the email?
Perf Daily Clips, November 25th, 2015.
Under the subject, does the email state, Chicago releases dashcam video of fatal shooting after cop charged with murder?
Yes,
And that's an email sent when?
that's sent on November 25th, 2015, approximately
I'm sorry,
10:30.
what date?
November 25th, 2015.
Thank you.
Your Honor, the state offers CPD email 13.
I'm sorry, you said OCPD email 15, which is tab 15.
Okay.
Other than any other objections other than what's previously been stated, Mr. McKay?
No further objections. Maintain the previous ones made.
Okay, Mr. Pugh,
No, Your Honor.
Mr. Beatty,
No, Your Honor.
your objections noted but overruled.
Your Honor, the state offers CPD email 13, which is tab 15, for a clear record at this time. I
The
believe,
objections noted but overruled. Thank you. The identification mark is stricken. It is admitted.
thank you, Your Honor.
Thank you.
With the court's permission, may I show People's Exhibit CPD email 14, which is tab 16 at this time, Your Honor.
Yes.
Mr. Maris, I'm showing you CPD email 14. What is that?
Here's an email from the CPIC sent on Monday, December 7th, 2015 at 11:05 a.m. to various individuals.
And it's cpic at chicagopolice.org. Is that right?
That's correct.
And CPIC is the same crime prevention and information center that you testified about earlier.
Yes.
When was CPD email 14 sent?
Monday, December 7th, 2015 at 11:05 a.m.
Did the Chicago Police Department keep CPD email 14 in the course of its regularly conducted business activity?
Yes.
Did the Chicago Police Department keep CPD email 14 at or near the time the email was sent or received in the course of its regularly conducted business activity?
Yes.
Did the Chicago Police Department keep CPD email 14 under the Illinois Local Records Act and Illinois law?
Yes.
Could you turn to page 3, Mr. Maris? Let me know when you're there.
Right here.
What is the subject of the email?
Perf Daily Clips, December 7th, 2015.
Could you turn to the next page, Mr. Maris, and let us know when you're there?
I'm here.
Does the email state Chicago cops' version of teens killing at odds with video?
Yes.
Chicago police officers who watched one of their own shoot a black teenager 16 times filed reports depicting a version of events that contrasted sharply to what was captured on dash cam footage. The city released hundreds of pages of documents late Friday pertaining to the officer-involved shooting. Is that what the email says?
Yes.
And remind us again what that email is dated.
December 7th, 2015.
Your Honor, the state now offers CPD email 14.
Any additional objections, Mr. McKay?
No additional objections, Your Honor.
Mr. Pugh?
We'll stand.
Mr. Beatty?
No, Your Honor.
All right, your objections noted but overruled. You said you're offering it into evidence at
Yes,
this
Your
point? All right, the identification mark is stricken, it's admitted.
Thank you, Your Honor. With the court's permission, may I show People's Exhibit CPD email 15, tab 17, to the witness?
Yes.
Mr. Maris, I'm showing you CPD email 15. What is that?
There's an email from Anthony Rogic at chicagopolice.org. It was sent Saturday, December 5th, 2015 at 1:22 a.m. to Daniel A. Gallagher. The subject is info.
Thank you, Mr. Maris. What is the first line of that email in the body starting with Dan?
Dan, FYI, sent below so FOP could let officers know. Original message from Rogic. Anthony T. sent Saturday, December 5th, 2015, 1:19 a.m. Central Standard Time.
Mr. Maris, could I ask you, after Dan FYI sent below so FOP could let officers know, is that a chain email that appears next with an original message?
It is.
Could you tell us who that original message is sent from, to, and when it was sent?
So the original message is from Anthony Rogic at chicagopolice.org. Sent Saturday, December 5th, 2015, 1:22 a.m. to Daniel A. Gallagher.
Did Anthony Wojcik carbon copy or CC anyone?
He did.
Who did he CC?
Dean Angelo, Thomas J. McDonough.
Just so we're clear, the email is to Dean Angelo, carbon copy Tom McDonough, is that right?
Yes.
After the subject of info, does the email state, Laquan McDonald investigation? Think it would be wise to alert all officers.
Yes.
Does the email also state, check Tribune site for article/file, Lieutenant Wojcik, Area Central, DD?
Yes.
And the email states it would be wise to alert all officers concerned for their awareness/safety. Is that right?
Yes.
And it goes on to state that the department and the city released the Laquan McDonald investigative file to the public without alerting us, Area Central, or without having redacted our or other officers' names.
Yes.
Did the Chicago Police Department keep CPD email 15 in the course of its regularly conducted business activities?
Yes.
Did the Chicago Police Department keep CPD email 15 at or near the time the email is sent or received in the course of its regularly conducted business activities?
Yes.
Did the Chicago Police Department keep CPD email 15 under the Illinois Local Records Act and Illinois law?
Yes.
Your Honor, the state offers CPD email 15.
Any additional objections than what you already made, Mr. McKay?
No, Your Honor.
Mr. Pugh?
No, Your Honor.
Mr. Green? I'm not Mr. Green, Mr. Bailey.
No, Your Honor, thank you.
All right, then the identification marks are stricken. It's admitted over the defense objection.
Thank you, Your Honor. With the court's permission, may I show People's Exhibit CPD email 12, turning back in the binder, tab 4 at this time.
Yes.
Mr. Maris, could you let us know when you're there?
I'm there.
What is that email?
Email is from Gallagher Daniel A. Daniel Gallagher at chicagopolice.org. Was sent on Thursday, September 10th, 2015 at 5:09 p.m. to training at forcescience.org, and no subject is listed.
Does the email state full name Daniel Gallagher,
It does?
rank sergeant,
Yes.
agency Chicago Police Department,
Yes.
agency address 5101 South Wentworth, Chicago, Illinois 60609,
Yes.
email address dgal27@hotmail.com,
Yes.
and that's dgal27 law&crime27@hotmail.com.
Yes.
At the bottom of the email, what is the signature state?
Dan Gallagher, Sergeant, Area 1 Environmental Crimes, 312-747-8380.
Did the Chicago Police Department keep email 12 in the course of its regularly conducted activities, business activities?
Yes.
Did the Chicago Police Department keep CPD email 12 at or near the time the email was sent or received in the course of its regularly conducted business activities?
Yes.
Did the Chicago Police Department keep CPD email 12?
That will stipulate to what Mr. Watson's going through for the sake of brevity. You know, not, still preserving our objection.
I understand. What's the stipulation? Just so I know.
Your Honor, we are laying foundation for the being public records and being business records.
Your Honor, on behalf of Joseph Walsh, I believe that if each of these emails comes in, that the witness would testify the same as to each of them, that they are business records kept in the ordinary course of business by the Chicago Police Department and public records. Therefore, maybe we don't need to lay the foundation for every single one.
Fine. So you're stipulating basically to the foundation for these exhibits
We would,
without
waiving our
without waiving
objection.
your previous objection.
That is correct.
That stipulation is received and admitted. Thank you.
So stipulated, Your Honor. State offers CPD email 12.
Did any further objection other than what's already stated, Mr. McKay?
No, Your Honor.
Mr. Pugh?
No, Your Honor, I wouldn't have a further objection unless I voice one.
Thank you. Mr. Fahey?
Judge, same with, on behalf of Thomas Cat. If I have any further objection, I'll voice it.
Perfect, thank you. So the identification mark is stricken on CPD email 12. It is admitted.
Thank you, Your Honor. With the court's permission, may I show People's Exhibit CPD email 1, tab 5 to the witness?
Yes.
Mr. Maris, could you turn to tab 5 and let us know when you're there?
I'm there.
I'm showing you CPD email 1. What is that?
It's an email from dgal27@hotmail.com, sent on November 2nd, 2014, 4:07 p.m. It's to Anthony Rojic at chicagopolice.org, CC Daniel Gallagher at chicagopolice.org, subject police shooting.
dgal27@hotmail is the same dgal27@hotmail address that you previously identified as Daniel Gallagher.
Yes.
Does the first line of the email from Daniel Gallagher's personal email address to Anthony Wojcik state, Van Dyke is aware 911 caller has been attacked with a deadly weapon, a knife, offender, nonverbal, only growling, acting in a menacing manner?
Yes.
Judge, I have to object at this point because it's a misstatement. It's not the first line. If you look at the email, the first line's been redacted. And I would ask that that redaction be removed in both places on this particular email.
Mr. Watson?
The state received this email redacted through its Garrity filter process. If the defendants are waiving any Garrity-related objections, then the state will obtain a copy of an unredacted email and offer that one to each other.
On behalf of David March, I am.
Okay. Mr. Pugh?
Judge, on behalf of Joseph Walsh, I can't make an objection without knowing what the redacted portions are.
Mr. Fahey?
Judge, I would agree with that. I don't know what the rejected portion is, so I can't state the objection.
And it's hard for the court to rule because I don't know what the redaction is.
Your Honor, the state will obtain a copy of the unredacted email from its security team. I'll note for the record that the defendants received the
I thought they received everything unredacted.
correct. Your Honor.
That's my recollection. Did you not receive this, Mr. Pugh?
Judge, I have a hard drive with thousands of emails. I'm not suggesting that it's not in there somewhere, but I'm being asked right now at this moment. So I can't object to something that I don't have right now and know what it's at.
Sure. Same for you, Mr. Fahey.
Yes.
Do you have it, Mr. Fahey?
Yes.
Okay.
Judge, I guess you reserve ruling on this issue until
I'm gonna
Mr.
take-
Watson's seen it.
I'm just going to take a short recess at this moment so the parties can.
Thank you.
Well, I don't want Mr. Watson to see it at this point because you don't have an objection, Mr. McKay, but I don't know about Mr. Pugh and Mr. Fahey. So I'm going to give them an opportunity to take a look at it.
Thank you, Judge.
So I said we're taking a recess. I'm just actually not recessing. I'm just going to let you take a look at it and see if we need it.
Okay.
Your Honor, on behalf of Joe Law, Jim, would find Mr. McKay objection.
Okay. Mr.
Judge, we will
Fahey?
also join in the objection. This is taken.
Okay, so you have no objection to Mr. Watson looking at it?
None whatsoever.
Okay, so you could look at it, Mr. Watson. I don't mean just Mr. Watson and the prosecution team.
I will ensure that the prosecution.
All right, and if you need a moment to discuss it, then let the court know.